Ramiro, we're ready to get started.
Thank you, Sophia. Hi, everybody. How are you? Thank you for joining us. Let me first introduce myself. My name is Ramiro Alvarez Ugarte. I'm a researcher at CELE, a Center for Study on Freedom of Expression based in Buenos Aires, Argentina. And let me welcome you on behalf of the Global Freedom of Expression Project at Columbia University. I will just briefly present or introduce a research project that we developed during last year in Global Freedom of Expression, which basically was an attempt to capture and analyze new trends and new case law on violence against journalists around the world. We worked with 6 regional researchers that worked in Europe, in Asia, in Africa, in MENA, in Latin America, and in North America, and the UN system. And we managed to identify new cases and analyze decisions on violence against journalists that apply international standards and that advance a certain vision of how states and how judicial officers should respond to a problem that it's pervasive around the world, that has different characteristics and features, but exists there nevertheless. This project is, as the Global Freedom of Expression project in Columbia University, is very focused on case law, on trying to understand what role judges play in sustaining freedom of expression around the world. But we will have today a discussion that will discuss standards, but we'll also gain the perspective of how the problem is seen by local practitioners, advocates, and NGOs. For that purpose, we're joined by Karuna Nundi, who's an advocate at the Supreme Court of India and an expert on freedom of expression and international attorney. She was our lead researcher for the Asia region in the GFoE project last year. We're also joined by Rajini Nagpal, who is a senior associate at Mrs. Karuna Nundi's chambers and who also worked in our research last year. And we're also joined by Gayatri Venkiteswaran, assistant professor of media and politics at the University of Nottingham and Malaysia. Sadaf Khan, who is a co-founder of Media Matters for Democracy in Pakistan. Pavitra Ramanujam, project coordinator at the Association for Progressive Communications, or APC. And we will have that discussion today. So thank you everybody for joining us. Karuna, whenever you're ready, you have the floor.
Thank you for that, Ramiro, and thank you for helming this project along with Sophia and your other colleagues in such a easy and enjoyable way. When a bit of background on this, when we all came together in, I think, what was it, 2015? I can't remember. There were people like Galina Arapova, who is one of the leading freedom of expression lawyers in Russia, Hossam Bahrat from Egypt, and a number of other people who have faced themselves now, even as lawyers, very serious criminal cases, detention, and other difficulties while they have been representing journalists and, you know, media and FOE in general. But it was an incredibly hopeful group and idealistic group in a very hopeful time. And one of the most important things I think that was born from it was this aspect of the project, which is the database. And so what is the database? The database is basically laws, no, not laws, but decisions from around the world that are significant with regard to freedom of expression. Now, it's not that they're all good practices. And I'm glad that we've stepped away from the term best practices in acknowledgement of the fact that all of this is so contextual, And, I used to work in New York as a policy person for the UN, and I was very young. I was 26, and at that time, I realized very, very quickly that sort of understanding nuanced and context is everything. You know, so yes, good practices, and it also talks about decisions that have gone not so well. You know, and I think both are important, and this is the reason that we uh, uh, despite having many other commitments, our chamber worked with Ramiro and Global FOE, Colombia, our panel on this, because I think it's very important. Why is it important? Around the world, we have a suppression of freedom of expression, suppression of media. And almost every country we looked at had the state suppressing journalists and media in some way, shape, or form. Now, where does that leave us? That leaves us, and I think as lawyers, while some of us also engage in advising movements and civil society, and I'm sure many of you do because some of you are activists, um, I think for lawyers, one of the first ports of call have tended to be courts. Now, some of us are now stepping away from that, right? Because it needs, and in recognition of the fact that any approach needs to be multi-pronged, depending on what problem you have and what is likely to work to solve the problem. It has to be incredibly strategic now, and way more so, given that you have um, a sort of multi-pronged suppression by the states in these various countries, as well as the fact that you now, in many of these countries, have a nexus between corporates that seek to suppress speech, as in conjunction, in some places, with governments that seek to do so. Now, courts are the bulwark, of course, and in theory. But the research that we did gave us a fairly patchy, I think, set of results as to how well our judges are playing that role in our region. Um, and I do, have they been uploaded yet, Ramiro, these cases?
Not yet. We're in the process of uploading them slowly.
Okay. Okay, so you get the preview. um,
We should have them all by April the 1st. They should be all uploaded.
Great. So, and the thing is that I think that there are some hopeful examples here. So I think that's important, because given that judges in any particular jurisdiction have been performing in ways that are sort of not entirely consistent across the judiciary. Most of us have, I mean, of course, everyone has a polyvocal judiciary. In our country, we have a polyvocal Supreme Court. We have all these different benches. I practice primarily in India. I mean, no, my main municipal jurisdiction is India, and my international law is in various countries. And therefore, I think that a strategic decision on where one will bring one's case. And also, I don't know if we have the ability to seek live questions, but there's some way in which questions and answers can happen, right? So so anyone, please raise your hand if I'm getting too legalistic, or if you have any questions. And I would like to keep significant time at, in the end for questions. So I'm not going to go on for too long, because so strategically choosing your forum, I think, is extremely important. Once that forum is chosen, because countries have commitments in international law, and comparative law can be persuasive in in many jurisdictions, depending frequently on which other country you are citing and which other bench you are citing. Um, and also because depending on the route that you are taking, I'll come to Magnitsky sanctions, etc., briefly later. Because these solutions and here statutory innovations are new, courts are open to looking at the jurisprudence of other jurisdictions. I think that the work that is happening on the database is now vital. I now think that it's incredibly important, given the battles that we are all fighting. Now, let's look a little bit at, briefly, at our contribution here that was helmed within chambers very ably by Ragini with my guidance and supported by Muskan and other colleagues. So we analyzed case law from India, Pakistan, Bangladesh, Hong Kong, and the Philippines. And these countries all rank fairly low in the World Press Freedom Index. India ranks at 142nd of 180 countries, and this is the 2021 index. Pakistan's at 145, Bangladesh is at 152, Philippines is at 138, and Hong Kong is 80th. So here, what are the various kinds of cases that we came across? And some of the most significant and interesting ones on the database, but we came across, many, many different kinds of cases, right? There were cases where there was violence against journalists by non-state actors. In some of these cases, the prosecution was proceeding quite slowly, but the good practices were that there were times that it was recognized that the person was being targeted because they were journalists. And in some cases, that was then treated as an aggravated offense, some of the greatest violence against journalists and the killings of journalists in India, and it happens in India far too much for comfort, and it happens in the smaller places and it doesn't get reported internationally. And very frequently in in our region, we find that the murder is not treated, or the violence isn't treated as violence because the person was conducting the reportage that they were. And so this recognition, I think, is very important, not only because of the possible result, which is that one can set a good precedent and seek to have it treated as an aggravated offense, but also because you're much more likely to get to the answer, quite frankly. Your investigation is going to is likely to be much more accurate. When you have violence by state actors, and in violence, we sort of went a bit back and forth as to how broadly we should define violence. And we decided to, of course, include disappearances that seem to be by the state, but also accusations and trials under anti-terror and so-called national security. Well, I don't want to say so-called. I mean, some of it does promote valid national security reasons and goals, but many of these laws are, of course, hugely overbroad and don't require the state to provide rigorous evidence at the threshold to allow detention. And here, most frequently, we found that there was a massive deference to the national security, the fact of national security. We found that all the state has to do is say, hey, I'm using the national security law. So give me some time with this person in detention, because of course I have to investigate further and I have to find out, exactly how how they have breached national security, which is of course putting the cart before the horse, right? But I think that tentativeness and that that fear comes from the fact that of a judge to grant bail at that stage, even if, and this is very important, the process of the law, if read strictly, and we must remember that judges are required to read process in criminal law strictly and construe it strictly, right? And they don't very frequently in the cases of national security. It's because you don't want to be that person. You don't want to be the person who released the chap accused of, you know, allying with those who are trying to overthrow the state, you know? So just the invocation of those words seems to act very frequently like a totem and is being used in that way. And to counter that, I think the database is going to be quite helpful, because there are good practices where courts have stood as that bulwark, right? Reminding criminal courts and reminding courts that are dealing with national security laws that your work as someone who is sitting in that position is not merely to protect your nation from sedition or terror or such terrible things, but it is also your duty to read what you are, your statute strictly, and two, to read it in light of your constitution and freedom of speech, and thirdly, to read it in the light of your international commitments. And many of these countries have commitments to the ICCPR and to the UDHR. Of course, you know, amongst other instruments, but of course to the ICCPR and the UDHR, many of these countries do have those commitments. I mean, as an aside, like, we must remember that international law is not as fuzzy as the Russian-Ukraine conflict has left us feeling. Many jurisdictions still are quite clear that where there is, and there are various agreements between, say, judges in, and the jurisdictions that we looked at are mostly common law jurisdictions. We have a common law, we have India, Pakistan, and Bangladesh are common law and mixed jurisdictions. Pakistan is, of course, part Sharia. And we have Hong Kong, of course, and then we have the Philippines, which is also mixed. India is also in some ways, and Bangladesh are also in some ways mixed, because India, because of its personal laws. But the point is that there have been various statements by common law judges and from the Bangalore principles onward, and various decisions from around I mean, you know, I'm not crazy about the word Commonwealth, but you know, common law jurisdictions, TO in Australia, etc., and Vishakha here, saying in India, saying that at the very least, at the lowest threshold, where there is a gap, where there is a lacuna in your domestic law, then you must abide by international law, right? And so there are various ways in which that those international commitments may, and in fact, I think it's our duty to push the envelope there, must be pursued. Now, I think Ragini quite liked the decisions in Rana Muhammad Arshad by the Islamabad High Court and in Matiullah Jan. So I'm going to leave those to her. But I think that when we look at decisions like Gautam Navlakha's in India and Shahidul Alam's in Bangladesh, one thing becomes clear is that the process in a criminal matter is everything, right? And where the process and particularly in many of our jurisdictions where a criminal case, even a criminal case, takes a long time, bail is therefore then incredibly important. Bail then becomes almost everything, right? Because you have huge numbers of people who are in jail, not convicted of anything, just pending trial. So therefore, we have the Shahidul Alam's case was an example of the Bangladesh courts saying that, look, you can't just say something is, and that was a case under the now repealed Section 57 of the Information and Communication Technology Act. And he was being investigated for a live video, extremely renowned journalist, that he had posted on Facebook, and the comments he made for the comments he made in an interview about protests by Bangladeshi students against the government. So Section 57(2) was this: it provided for punishment for publishing fake, obscene, or defaming information in electronic form, and was punishable with imprisonment for a term of 10 years. Right? Now, this kind of vague and overbroad sort of provision, and that you don't even know what it really means. You're just throwing everything at in one section. You have fake news, you have obscenity, and you have defamation in a criminal form in one line without it being adequately and specifically narrowly defined, right? We had a law like this, Section 66A of the Information Technology Act, and I represented the People's Union of Civil Liberties, and after about 50 years, for the first time, the Supreme Court struck down a criminal speech provision. And so I'm glad to see that this is gone. Sadly, many cases like this, many sections like this remain. And so therefore, the fact that 4 judges of the appellate decision of the Supreme Court upheld the stay order of the High Court is something that is very welcome. As I was saying, interim orders are important. Okay, Ramiro, I'm just going to finish up here. I believe I'm running out of time. Now, in terms of the in terms of the jurisprudence that we have looked at, it is of course mixed, as I said. The Gautam Navlakha decision is a decision in the opposite direction, because how you measure the temporal nature of house arrest, for example, in the Gautam Navlakha decision, was being decided by the Supreme Court, and on really a very tiny technicality, that decision was made against the person who, on very dramatic allegations, but practically, but evidence that has since been submitted before the Bombay High Court as being concocted by the state. Gautam Navlakha wasn't granted bail at that point, and it's now what happens is that at the time, his wife then was not able to visit him because of COVID. He wasn't being allowed to speak on the phone from jail, and that small tweak in judicial interpretation is something that has destroyed a family's lives. Now I'll move on to my colleague Ragini, who will take over and speak about some of the, I'm going to leave it to her. Thanks.
Thank you,
I'd be
Karina.
glad to take questions later.
Thank you, Karuna. Ragini, you have the floor.
Thank you. So what I'll first talk about is, while we were going through these cases in various countries, Pakistan, India, etc., there was one case, actually a couple of cases by the same judge, that I thought I found them very inspiring when I read them, and I thought they were very impactful. They are by Chief Justice of the Islamabad High Court, Justice Minalla. And the judgment is Rana Muhammad Arshad versus the Federation of Pakistan. And he also authored the decision in Matiullah Jan's, the journalist Matiullah Jan's case. In both these cases, there was persecution against the journalists for their critical reporting. And they are very vocal critics of the government, as I read. And in both these cases, what Chief Justice Minalla did was, yes, he said that investigative authorities have to follow, they have to act justly, fairly, etc. But a large part of these judgments focus on what it means to persecute the journalists, what the implications are, not just on the journalists, but on a country, on the country as a whole. So what he said was that he begins his judgment, and he begins his judgment by quoting George Orwell, and he says that if liberty means anything at all, it means the right to tell people what they do not want to hear. And he goes on to say that an apprehension or fear in the mind of a person who is engaged in the occupation of reporting is intolerable in a society which is governed by a constitution. And he says, and I quote, that freedom of speech and expression is the most cherished human right, and it fortifies all other constitutionally guaranteed rights. What he does in these decisions is that there is a correlation between Article 19 of their constitution, which is similar to in the Indian constitution. And they also have Article 19A. So 19 says that every citizen has the right to free speech and expression. And 19A says that all citizens have the right to receive information of public importance. So in these decisions, the judge says that it's the court's duty to fiercely protect the sanctity of these rights. Because when you violate 19, you violate 19A. And for a country to grow in the right direction, economically, and in all other ways, he says it's very important for there to be a free press. And he uses this phrase. He says that press is like a safety valve for citizens and various other groups, etc. And it's like an antidote to poverty, to corruption, etc., etc. So these are the things that I found inspiring when I read this judgment. Coming to the role, as I was reading these, when we were working on this project, what is the role of a judiciary? And what are, in certain circumstances, what are the limitations and what are the challenges that they are likely to face? So for example, like Justice Minalla said that the press is a safety valve. In a similar context, when you talk about the legislature, the executive and the judiciary, it's the judiciary that is a safety valve to the legislature and to the executive. If a law is constitutionally bad, it's the judiciary that strikes it down. If executive policy is bad, the judiciary is the one that will review it and strike it down. Although, at least in India, the courts are, they do exercise a bit of self-restraint when it comes to interfering, because we also follow a theory of separation of powers, where one organ has to remain within their domain. But having said that, it is the courts that review legislative action and executive policy. And which is why I feel that when we speak of the role of a judiciary, the judiciary can be, it has the potential to be incredibly powerful, subject to it being independent. And the level of independence of the judiciary in every country is, of course, different. There may be political influence, there may be other pressures, which many times judges may succumb to. So subject to a judiciary being independent, I think they have the potential to be extremely powerful. And one challenge that I think courts face is when the perpetrator of the violence against the journalist is a non-state actor versus when it is a state actor. So when it's a non-state actor, for example, if somebody did not like the journalist reporting against them and they abduct the journalist, it's a clear-cut, it's illegal. So the courts will say, okay, these were the facts, this was illegal. However, when it's a state actor, what ends up happening is that the state will always levy charges. They'll say, okay, the Information and Communication Technology Act, or for example, in Hong Kong, or in so many jurisdictions, the national security laws. So what happens in these cases when it's a state actor is that the court has to then traverse an extra mile to see that, okay, is this charge legal? Is the act done pursuant to these charges, say the arrest or the kidnapping? Is that legal? So I think that's an additional challenge. And state actors often use this as a smokescreen or as a to give it a normative veil of legality, as Karuna ma'am puts it. So I think in order to be able to, I think there are some guidelines that are required over and above the existing law, the procedural law of the land, to be able to help courts, any courts, lower courts, appellate courts, etc., to be able to understand that even when the perpetrator of the violence is a state actor, this is what needs to be done. These are the safeguards, and this is the process that we should follow, so that there is justice for the journalist. And lastly, I think all courts, be it lower courts, be it constitutional courts, especially when lower courts are so bound by procedure of evidence, the criminal law, evidence, etc., where they have to follow, in India, the Criminal Procedure Code and various other laws. At the end of the day, I think all courts must remember that they are all bound by the Constitution, and that is the law of the land. And that needs to be fiercely protected and guarded, because that's what the court's mandate is. So I think that's how I'll end.
Thank you very much, Rajini, and thank you, Karuna. You both shared a side of the issue that is very important, which is the role of judges in dealing with this problem. Of course, what we found in the whole project and in different regions, and especially in Africa and Middle Eastern countries and North Africa, we found that a lot of the cases of violence against journalists are not specifically discussed as cases that violate freedom of expression. So that's one of the concerns, and that's why some of the decisions that you both highlighted and that you both found and analyzed are so important, because they take in particular the issue of violence as a violation of freedom of expression. In many cases, what we saw in other regions specifically is that cases of violence are treated as cases of violence, and harassment is treated as a case of harassment, and the freedom of expression dimension of the case is not really discussed. To have a more general take on the situation on violence against journalists in Asia, we have three speakers and commentators, and I will first give the floor to Gayatri Venkiteswaran, Assistant Professor of Media and Politics at the University of Nottingham in Malaysia. Gaya, the floor is yours.
Thank you, Ramiro, and also thank you very much to Karuna and team for sharing the report and doing the report. I think it's such a timely thing, and really, to keep the focus on, keeping the eye on the ball, so to speak, in terms of safety of journalists. And you're right, it's been many years since the first database was launched. And I think when you mentioned earlier about not just best practices, but also, keeping an eye on how the laws have been used, or the courts have, sort of acted contrary to what we would have liked them to do. But I think it's also important because in Southeast Asia, for example, where I have spent a little bit of time on activism and also advocacy, it has gotten very sophisticated in terms of how the governments have enacted new laws or interpreted the laws that they themselves have legislated, whether it's in the interest of national security or in the last few years in response to the pandemic. And so having a liberal interpretation for their gains, rather than having a liberal interpretation in the interest of press freedom and freedom of expression. And they've grown so much more sophisticated that I think civil society actors, advocates for legal reforms, judicial activists need to keep up with how states are in fact looking at each other in this region to tighten the laws and in fact make it much more difficult for freedom of expression. So I think the database is really important for us to be on our toes, really to catch up with, I think, what is really the growing trend in authoritarianism within the region. Karuna, there were a couple of things that you mentioned. I really do want to take on from that, because you're absolutely right that even when we have a focus on the judicial advocacy, we've seen in the region how lawyers, judges, prosecutors themselves have come under threat, where they are representing or hearing cases that involve freedom of expression, freedom of association, media freedom. For example, in the Philippines, the ICJ has in fact found that, if I'm not mistaken, at least in the last few years, at least 61 lawyers, judges, and prosecutors actually have been at risk. Some of them have been, in fact, killed because of the kind of cases that they have taken on, the positions that they have, advocated for. And this is also very contextualized within Duterte's region, the current regime, the current president. And so the risk is also there for those who are fighting for the rights of or taking up cases that involve journalists, journalist killing, journalist threats. There's a huge issue of red tagging that happens, for example, in the Philippines. It's growing now again in Indonesia, within this region, that puts all of these people also at risk. And so there's a real threat now to those involved within the judicial system, whether they're lawyers or prosecutors, who are taking up all of these cases. So I think that's a real concern, and I'm really glad that you brought that up as well. I do think that there's such a gap here within the region when it comes to referring to international standards. Of all the countries within Southeast Asia that has somewhat, a more open and have adopted international standards within their constitution. If you look at Cambodia, for example, it's written in there that they have to defer to international standards where there are gaps. But the reality on the ground is something that's completely different. Situation has gotten from bad to worse in Cambodia, as far as the rights of independent media, journalists, threats against them under the Hun Sen regime. So I think I guess in terms of the standards and the application, there's still a huge gap. Excuse me. So I would like to look at two, I suppose, countries really in terms of the discussions, Indonesia and Philippines. Just excuse me, it's like a really bad, I'm just going to turn off for a while. Sorry about that. Indonesia and Philippines, where there have been a very strong civil society movement. In Indonesia, there have been a great activism by, in fact, the Press Council in representing media freedom, as well as working with state institutions to have agreements to make sure that cases that fall under press freedom are are seen as, in the first place, in the interest of the media, to minimize criminal defamation or criminal actions. 3 years ago, they've actually set up a committee in order to promote or actually to campaign for much greater safety for, excuse me, safety of journalists. Philippines is now one of the cases or one of the countries under the UNESCO's UN Safety Plan for a multi-stakeholder approach for greater involvement of civil society, the government, and also other NGOs in order to actually tackle the problem, because both these countries continue to have very high levels of unsolved cases. At the moment, 14. Actually, I think 14 only under the current regime in Philippines, and there are 8 unsolved cases of deaths of journalists or killings of journalists in Indonesia. So these are quite high in that sense. But despite actually very, very strong movements across the board among journalist groups, NGOs, it is very difficult really to pressure the judiciary and the legislators. In Philippines, there was actually a really good Supreme Court judge who was really setting the stage, especially in the case of the Ambatuan massacre, which you mentioned in the report as well, that that does not, maybe it's a missed opportunity to look at the case from a press freedom and freedom of expression point. Supreme Court was the Supreme Court chair was actually removed under Duterte. So I think there's still a lot of political involvement that prevents the kind of action that even prevents the courts from actually making much more headway when it comes to solving cases of journalist killings. I would also just maybe highlight in terms of strategies. I think what we see growing in the region is that a lot of the reportings that put journalists at risk, which is not new, it's definitely a global issue, is that it involves corruption. It involves the reporting of environmental issues, destruction, land rights or land grabbing. And I think there's actually a lot of opportunity to involve a lot more non-traditional FOE groups within these networks. In these countries, we see that the main proponents or advocates to end impunity in killing is that it's moved by, or it's sort of pushed by journalist groups. But I think that it actually is far more important to involve environmental journalists, to involve land rights movements as well, because these are issues that are being brought by a lot of the reporters and the journalists who are now, we've seen actually cases of killing or threats. And also freedom movement, for example, in Papua, in Indonesia, in the case of Myanmar, even before the coup, issues of ethnic rights put a lot of these journalists at risk. And I think a much bigger multi-issue or thematic-based support would be really, really helpful in order to expand the voice, really, in that sense. Yeah. So taking it out of just the media alone and actually saying this is a societal issue, because we're dealing with violence, we're dealing with issues that are at the core of a lot of people's fundamental rights. And the messengers are actually being targeted for this. And I think that kind of pressure may actually be necessary to push both legislators, who seem to be becoming more and more I suppose, inclined to see mainstream media and fake news within the same paradigm, which is very worrying. So there's a distrust by even legislators of media. And so they are now also becoming very difficult to advocate to have legal reforms, for example. And in many of these countries in Southeast Asia, I would say that the courts will respond and say, if the law is in that way, that's as far as we go. So, I mean, Ragini, it'll be great if the courts in Southeast Asia were far more active in that sense, activist-minded, like in India. But they work within the confines of what is there in the legislation. And I think what is needed really is to get the legislators to push some of these legislations to broaden the interpretation. But there seems to be a lot more resistance coming from legislators. So I think maybe just to think about how to move forward in some of these cases, a much broader kind of a coalition that covers beyond the media, because of the issues that matter to a lot more groups in that sense. I think focusing on legislators is really, really important to reform the laws that we have, which at the moment I think tie the hands of the courts, at least in some parts of Southeast Asia. And I think that is probably the two main things that I think we might need to see, or at least focus in the years to come. I'm so sorry with the interruption, but yeah, it's just in the spirit of being COVID sensitive. It's like, we've been very careful, and all of us have been very, very very wary of even small things here. Anyway, I think, Ramira, I will end there.
Thank you, Gaia. Thank you very much for sharing your perspective on these issues and highlighting the importance of legal reform to combat this problem. Sadaf Khan is the co-founder of Media Matters for Democracy in Pakistan. Sadaf, you have the floor. Sadaf, we can't hear you.
I think you're still on mute, Sadaf.
Yes, I think so.
Yeah.
I'm sorry, Sadaf, we can't hear you. Perhaps we have a technical problem.
Is it
unusual? Perhaps I will give the floor to Pavitra as we solve your audio problem. Okay. Okay, Pavitra Ramanujam. She's the project coordinator at APC, the Association for Progressive Communications. Pavi, you have the floor, and in the meantime, we will solve Sadaf's audio issue.
Thank you so much, Ramiro, and hi everyone. Thanks so much for inviting me to this panel, and especially to Colombia's Global Freedom of Expression program. It's been really fantastic to hear from Karuna and Ragini about the research, and of course, always from Gaia about the situation in Philippines, in Indonesia and the Philippines. And it just goes to show how crucial, I guess, the researchers and the databases as well in fighting violence against journalists in the region. And just from their interventions, I think it is clear that situations and conditions in which the journalists are working have become increasingly more dangerous. And it is also necessary to look at them, I guess, in the broader perspective of the political climate in the region as well, right? Of course, this has worsened because of the pandemic, but I think that all of us are aware that there has been a massive slide in many of the countries in Asia towards extremism, towards authoritarianism. There's been a massive erosion of independent institutions, of democratic practices. There's been an increase in surveillance, restriction on human rights through laws, through policies. And there's also, on the other hand, been a huge increase in hate speech, in misinformation, and in many cases where they've been weaponized and they've been targeted as a way to censor and control information and speech by both state and non-state actors. And as Gaia said, it is not just journalists, it is in fact, religious and gender minorities, it is civil society activists, it is lawyers, student groups, political dissidents. They're increasingly being threatened, and they're increasingly being marginalized for what they say and where they say it and how they say it. And so violence against journalists and all of these attacks on press freedom are obviously at the center of the storm, and it's very crucial that we work towards combating it, I guess, in an effort to stop this slide that we see right now. And I mean, of course, there is a lot of work being done, as Gaia mentioned, by civil society, by lawyers and others, and of course, there's a lot more to do. Just based on the findings of the report from what I heard, but also just what we've seen so far, I think that the biggest threats faced by journalists in the region have been as a result of state action. And this has taken place in a number of ways. I'm sure the report covers this as well, through a variety and increasingly innovative ways of legal harassment and criminalization, right? We have seen, for instance, of course, the usual civil suits and defamation, contempt of court proceedings, as in the case of Rappler or even Malaysia Kini. We've seen tax-related cases. For instance, it was in Cambodia, I think, where the Cambodia Daily was forced to shut down in 2017 because of the huge tax fines that the government imposed on them. In India, we have seen multiple raids and tax-related investigations on independent media houses. For instance, NewsClick and News Laundry, who have been subject in the recent past to IT raids, directly connected, very obviously connected to the reporting that they've done. There have been illegal detentions in Vietnam of bloggers and journalists, which incidentally, I think is the lowest in terms of the press freedom index in Asia, but probably doesn't get as much attention. There's been seizure of property, of equipment of journalists who are in the field that have been reported by journalists in Kashmir, in India. And of course, there is the use of really serious laws, colonial laws like sedition in India and in Malaysia, and a slew of national security laws, like, for instance, the way that the Digital Security Act has been used in Bangladesh, especially during on the reporting that's happened during the pandemic, right? And beyond this, just recently, the use of surveillance technology like Pegasus that we saw in India has, I think, just unearthed this new dimension of threat to journalists. And it really does feel like the state is able to use every apparatus that it has at its disposal, whether it is law enforcement or tax authorities or intelligence agencies, to really target journalists in a very specific way. And it obviously speaks to this huge culture of impunity that has been created in many of our countries. And I want to speak to some of the things that civil society has already been doing and perhaps should continue to do in an effort to support journalists and an effort to protect them against further violence. I think one of the crucial ways in which civil society can help really is to be able to find ways to provide more resources to journalists to fight some of the legal threats and harassments they face, right? I think Karuna mentioned this as well, because oftentimes journalists, especially independent journalists, journalists who work for small news outlets in non-urban areas, aren't able to fight many of these legal cases because of the huge financial burden that it entails. And also in many cases, because they don't have access to the right legal counsel. And so in this, there is an opportunity to be able to perhaps set up, I think, emergency response and support funds for journalists to help them through these cases to facilitate their access to counsel. Related to this, and I think that this is work, for instance, that MMFD is engaged in as well, there really is a need to build capacity of journalists, right? Not just in terms of their rights, their obligations under law, but really even in terms of, for instance, following sound financial and accounting practices in their organizations and in their independent practice, and really on ways to the extent possible to be able to establish their physical, digital and psychological safety. And to the lawyers who are also fighting these cases, to be able to support them, to be able to provide them capacity, both in terms of research and strategy, and also to be able to help them build a case, as all of the panelists pointed out before, to make sure that the cases are heard in the larger context of the journalist's work and not just necessarily with respect to the charges that have been laid before them. And I think another way perhaps that, again, work that is already being done, I know, for instance, in Pakistan and in Cambodia and in other countries in Southeast Asia as well, is engaging with the national human rights institutions, right? I mean, despite the fact that there has been significant erosions of many of the independent institutions we have in our countries, NHRIs do have a mandate to protect and uphold human rights, and press freedom is, of course, a crucial part of this. And so I think there is an opportunity also to undertake efforts to work with NHRIs to build their capacity to ensure that they're able to take special cognizance of some of these cases, and to really help journalists to hold states accountable, which is also an important part of their mandate. And I think just at the regional level, there is some opportunity as well. Just as this database is doing, right, and what the database hopes to do in terms of it providing a sort of a reference, a guide to others who are fighting cases, but also to be able to build and strengthen a network of journalists themselves as a way for them to exchange information, to share strategies, approaches, and even just solidarity. And this does help. International pressure on state-led harassment, detentions and arrests of journalists has helped in the past. I think, for instance, in the case of Maria Reza, the spotlight on her case and the situation that Rappler is going through did help them, even if it not diffuse the situation completely, but at least to stop the situation from becoming worse. And finally, I also think in this regard, there is an opportunity for civil society to put more pressure internationally on the use of surveillance technology. I think the recent decision by the US to blacklist the NSO group and to take an initiative to look at what states' responsibilities are when it comes to their human rights obligations with respect to spying on their citizens and journalists. I think there's an opportunity there to build on that as well. And I also wanted to speak very specifically on a particular trend, which Gaia mentioned as well, that we have seen in the region, especially during the pandemic, which has been just this absolute slew of laws that have come out that target freedom of expression and, of course, specifically press freedom and journalists as well. And I think that even more importantly, a lot of these laws have targeted much more than traditional journalism, digital media that's come up, right? And this has happened across the region. And I'm sure Sadaf will be able to tell us more about this. But for instance, in Pakistan, the recent the Media Development Authority ordinance, the new PICA ordinance that has been proposed by the government, which essentially allows them to censor journalistic content and criminalize legitimate speech of journalists. In India, of course, we have the IT rules on the intermediary guidelines and digital media ethics code that was published in 2021, which has actually a part 3, which has temporarily been stayed by the Bombay High Court, but which essentially is a code of ethics for the media and gives this redressal mechanism the power to reprimand them, to censor their content just based on complaints from pretty much anyone. Just on also to add to Gaia's point about how this legislation is copied, because just recently Bangladesh has come out with their own regulations for intermediary liabilities, which also contemplates a very similar code of ethics for journalists. And so it is hugely important for us to take cognizance of these laws and to also see how they're being sort of transferred across different jurisdictions. And of course, I think in Southeast Asia, there's been just a huge amount of fake news laws. In Malaysia with the fake news ordinance, but also really in Thailand, in Cambodia, in Indonesia, in all of these countries, there have been laws that target speech online, that target news, and that have severe criminal implications for journalists who are targeted under them. And so there really does need to be, I think, a huge effort, a concentrated effort to push back against these laws in multiple ways. I think the first thing would be definitely to raise more awareness among the general public on the impact of these laws. As Gaia said, it is not just targeting press freedom, it targets freedom of expression as a whole. It targets very many aspects of our lives. And so to have the buy-in of the general public, to make them understand the impact of these laws beyond just their impact on journalism, to build a broader coalition of civil society, of journalists and lawyers who are able to analyze these laws and effectively push back, to be able to track these laws, the passage of these laws as they come up, to push for civil society, for journalists, and I think especially women and other gender minority groups to be heard during the consultation process, which I know is not always easy. There are like short times for consultations. There are many suggestions are not taken on board, but to still push ahead on that. And then, as Karuna mentioned, if the laws are passed, to really be able to support and engage in strategic litigation to make sure that courts are pushed to strike these bad laws down. I think, for instance, Section 66A of the Indian IT Act is a really, really good example in how this actually works out. And finally, I think an important part of how we can combat these laws that target journalists is really also to be able to work with social media platforms, to engage them and to ask them to be much more transparent in the content that they take down, to be more transparent in the kind of data, the desegregated data that they provide, so that we have a better understanding of this nexus often that happens between state and these platforms. And finally, I also wanted to talk very specifically about this online dimension of violence against journalists. Apart from the threats that state actors pose to journalists, of course, there's also other threats by non-state actors as well. And I think a huge part of it in the recent past has been this spike in online harassment, hate speech, targeted at journalists, right? And this has included, death threats, rape threats, intimidation, doxing, religion-based hatred when the journalists belong to minority religions. And a lot of this has been really gendered as well. I think women journalists face far more harassment online than other journalists do. And for instance, we saw in India, there were these recent investigations that spoke about the tech fog app, which really it's the way for states to really target online harassment towards a whole range of people, of which women journalists were one of their primary targets, right? And I think there's a lot to be done here as well. Again, social media platforms have a huge role to play. They must be asked, they should be brought to the table and engage with civil society and journalists to enforce their policies on harassment and hate speech much better, to take the concerns of journalists on board and to be more proactive in how they regulate content on their platform. There is also a need, I think, to sensitize law enforcement in some way, because online harassment cases, and I'm sure Karuna and Ragini can speak more to this, they're simply not taken seriously. Cases are not registered, and if they are, action is rarely taken against them. And I think at the international level, finally, there can be a lot more effort to recognize, especially to gender-based hate speech and the specific kind of threats that and harassment that women and gender minority journalists face. And finally, I just want to talk a bit about the role of courts and what they can do. I know that already Karuna, Ragini, and Gaia have spoken to this quite a bit, but I will just make a couple of additional points. I think that there has been this trend of the process itself being the punishment when it comes to cases filed against journalists. Often, especially when they are filed in cases, for instance, under national security laws, bail is withheld. The cases are not taken to trial, and that is something that courts have a huge role to play in. Secondly, I think there is not often uniform application of the same laws by various courts within the country. Of course, there are different degrees of that within the country, but often sometimes the same courts can deliver two diametrically different decisions on similar issues of freedom of expression and targeting of journalists. And finally, really to take more cognizance, to reiterate this point made by others, take more cognizance of crimes against journalists and to place it in the larger context of the work that they're doing and freedom of expression issues that it entails. I will end here and by saying that I think there is a lot of work already being done in the region around this, especially I think by my fellow panelists here. But of course, there's still a lot more that needs to be done. Thank you.
Thank you very much, Pavitra. You mentioned several issues that are very important. And one that I wanted to highlight specifically is the gender dimension of violence against journalists. Within this project, we took particular care to expand the usual definition of violence to include online harassment, especially. And we found a couple of cases, especially in Europe, that are advancing this vision that take into consideration, in particular, this form of harassment. Now I will give the floor to Sadaf Khan from Media Matters for Democracy. Sadaf, you have the floor.
Thank you. Am I audible now? Okay, great. So since we're running short of time, I'll dive directly into it. Since my fellow panelists have mentioned multiple times the need for coalitions that involve more than journalists coming together, I want to highlight one specific aspect in Pakistan that we have seen developing over the last few years. Karuna, you mentioned that Pakistan is one of the countries, along with India, that fall quite low on the freedom of expression indices. We have had a large journalist safety and security issue. But one point for celebration, perhaps, is the fact that after working on it for like over a decade now we have seen a very organic and a very strong bond alliance developing between journalists, development actors, specifically media development, digital right actors, and the bar itself. So the cases that you mentioned, Ragini, for example, those cases in the Islamabad High Court, various other cases, including the defense and strategic litigation, public interest litigation, is being led by a journalist defense committee that voluntarily provides support to journalists, and that has come together voluntarily from within the bar. So we see the legal fraternity coming together in a very specific manner, a specific number of journalists, specific lawyers who have worked with civil society organizations like ours and others on developing skills, on developing understanding, on international standards, on freedom of expression, and kind of translating them into the local legal instruments. So I think the fact that the journalist union, the Federal Journalist Union itself proactively engages with legal instruments and laws, and also takes ownership of cases that are initiated against individuals. I think that has really strengthened the debate, especially the legal discourse around journalist safety and freedom of expression in Pakistan. After I think 16 years of advocacy, Pakistan has recently passed the Journalists and Media Workers Safety Act at the federal level and also in a regional level, which has created, it's just been passed, so the rules and the structures are still being developed, but it creates an independent media commission of sorts that which has the mandate to work on impunity, and not just impunity going forward, but also retrospectively on cold cases of journalists who have been killed, targeted, etc., and not been solved. So we've seen this after a very long struggle, these are some positives that are coming forward. Regarding the role of the courts, we are increasingly seeing more nuance in the discussions that is coming out of the court, especially in Islamabad. Ragini, you mentioned two cases from Islamabad High Court, but Justice Minula is also currently in the process of hearing multiple strategic litigations, and petitions that we deal with specific legal instruments. And within those discussions, even though we don't have the decisions yet, but just during the hearings, we see a very nuanced discussion on proportionality, on necessity, on disproportionate impact of certain clauses of laws, which is new for me, even though I've been working in this area for a very long time. Just having that nuance debated in court, even if when it's not reflected in so much nuance in the final decisions, but during the hearings, we are seeing these discussions coming forward, which then translate into media debates, which then kind of get much more mainstream, which is a very pretty good thing. Another thing that we are seeing is more questioning on the role of law enforcement, like police and the FIA, who are responsible for carrying out investigations under the laws. And various times recently, we have seen within courts discussion on procedural issues that are oftentimes neglected or just set aside when it comes to prosecution of cases against journalists themselves. So this very focused discussion on procedure itself, on bylaws, on violation of rules, etc., that is also fairly recent, and that's progressive. And we feel that it shows that at least the courts, or at least some courts and some judges, have started to take a more holistic view rather than just looking at whatever particular case they're hearing. So this, going back, taking a wider lens, making commentary and making comments on these cases and larger implication of these cases is very interesting. One thing that media rights activists especially have struggled with a lot in the past is the fact that freedom of expression and right to information within the general public is seen more of a right that's directed at media and the press. So what's happening with these discussions is that the discourse on mainstream media is also shifting from the journalist's right to people's right to access to information and journalism itself, which is very interesting. The challenges that we are seeing when it comes to, again, cases that deal with FOE or journalist safety, etc., are, I think, at three ends. First, within lawyers, even though we have the JDC, but overall, if I look at the lawyer community in Pakistan, there is still a lack of nuanced understanding of laws themselves, especially when they translate to online speech. So a lot of new litigation, a lot of new, at least, legal issues that are created for journalists, whether by the state or public or whoever. We have a lot of right-wing actors as well. They're done through not laws that are specified for the speech, like cybercrime law that governs content regulation online in Pakistan, but by the use of traditional laws. So there's still a lack of expertise within the legal fraternity in translating how that particular clause of the PP of the penal code or any other law translates to digital speech. So that's something that is challenging, and organizations, including ours, are trying to figure out ways to do that skill building there. Then, of course, the separation of power. I think, Karuna, you mentioned that in your talk as well. Oftentimes, especially during COVID, we have seen lots and lots of laws coming forward, literally being pushed forward without due deliberation, sometimes without even going through the parliamentary procedure, through ordinances, presidential orders, etc. So which have a very clear issue with either being ultra vires of the Parent Act if it's coming through the rules, or being, the vice is questioned or contradictory to the constitutional rights. So when this happens, when strategic litigation and public interest litigations are taken to courts, the commentary is still very progressive, but oftentimes the decision is not as strong as you would expect, because obviously courts always say that, this in the end is the parliamentary prerogative. So you see nuanced commentary, you see nuanced discussion during the hearing, but that doesn't often or in the same way translate into the decisions. That's something that we are seeing. And yeah, so strategic litigation, again, is something that advocates now are keeping as a side option and working as much as we can within the parliamentarians, with the legislators, etc., to figure out ways to make positive differences as much as we can before we actually take the issue to court. So that has both been a strategy and a challenge. Since we are almost out of time, I'll just add one more thing. Pavitra mentioned the issue with digital media platforms and women journalists specifically. So these are not cases you will see coming out of Pakistan, because we do not have, there is no legal jurisdiction that any of our law enforcement agencies would have over Facebook or Google or YouTube or whichever corporate is not taking down hate speech, let's say, against women journalists, even coordinated attacks. We have seen like intense and very constructed hate and insightful campaigns on Twitter specifically against women journalists, which are not often removed by Twitter, or at least not removed as quickly as they should have, and they spread, and sometimes they include videos, morph videos, including stuff that puts their life at risk. So this is an issue that we are kind of struggling with. Asia doesn't have a regional human rights instrument. Localization has its own challenges, related to data access to the government, for example, other threats that might arise to freedom of expression. So without localization, without having any overt legal power over corporations, we can't expect our judicial system or our criminal justice system to be able to initiate anything against the corporations when they become complicit, or they do not play the role that they should be playing in protecting women journalists specifically from these coordinated hate campaigns, incitement, etc. So that's one challenge that in terms of judicial action, we don't really know how to go about it, or what kind of legal instruments should be there to help deal with that. EU is much better in that sense. Obviously, they have the European Human Rights Code, they have the GDPR, they have the overall protective structure in place that allows localization to happen without new potential threats to freedom of expression being created. But in countries like Pakistan, it's not really so cut and simple. We can't advocate for localization without putting further issues, without risking further our freedom of expression. But without that, we can't hold corporations accountable, even when they're playing the role of being very active participants in a way, by not taking down the hate speech and the incitement proactively, or even when reported to in the way that they should. So that's one area where there is a gap in our legal instruments as well. And there's a gap in our own understanding, I feel, as civil society actors as well, on how to proceed, the best way to proceed. It seems like we're kind of caught between two very hard spots and not able to find the right. Ramiro, I will end there because it's 6:16 and I can see that you are getting anxious. So, but thank you for this opportunity.
Thank you very much, Sadaf. And thank you, everybody. I will give the floor to Karuna, who wanted to share with us some thoughts. Karuna? Karuna, you're muted, I'm afraid.
A bit of a metaphor there. No, I think we don't get enough of an opportunity, I think, to sort of come together. And I think these online discussions have made it so much easier. And so thank you, everyone. It's really been just the solidarity, and I think us coming together is just in itself important. I just wanted to say a couple of things that might be useful. I'm part of a media freedom panel that it's called the High Level Legal Experts Panel for Media Freedom, that was founded by Lord Justice Neuberger and Amal Clooney. And it's kind of rooted in as an advisory panel for 40 or 50 countries that have come together and committed to implement our recommendations. To some extent, it's happening. But the reason I mention it is because there is the ability, I think, for amicus briefs to be entered into cases where it will be useful. It won't be useful in every case. In some cases, it will be seen as a foreign hand sort of thing. But in some countries, in some contexts, it's something that will be useful. For example, we have a judge who has experience from the Inter-American Court that said that there was an extremely salutary effect that the intervention had there. Second thing is that this emerged from something I think Pavitra said, I'm not sure, is, as in my hat as a media lawyer, right? Like some of the media reportage that comes to me, either pre-publication and post-publication, these look exceedingly different. That vetting looks very different at both stages. Makes it clear, I think, that there are many gaps that can be filled if we conduct trainings or get lawyers to conduct trainings of media houses, and in this online world to record these trainings. And of course, these would have to be very jurisdiction specific to make reportage bulletproof as much as possible. There's some things you can't do, but as much as possible to make it bulletproof, right? If one is a jurisdiction where you have defamation against the state that is allowable, or defamation against a public figure, right? Against New York Times versus Sullivan and Derbyshire County Council, the two judgments that have traveled exceedingly well across the world, including to some extent in this region, right? Then we want to say that, look, you can say the same thing in this way. And there's sort of low-hanging fruit there. And so I think that's something that, and we also saw journalists doing very important work around Me Too and taking people's testimonies and then reporting them and then themselves being sued for defamation, right? So I think these trainings can be quite useful, and it's something that can go to scale because it can be recorded online and within each jurisdiction. Now, very quickly, Gayatri's point, I think, of broader coalitions, I think is vital, because I think the cultures of free speech in our countries are still emerging. Is free speech important? Like in some countries, it's considered something, for example, I was in the United States and I was talking to somebody in the airport bathroom, and she was cleaning the floor, and we were talking about just something, off the cuff, and she said, "But it's my right to free speech." You would never hear that. I think in India, I'm pretty sure you would never hear that in the same way in Bangladesh or Pakistan or, I mean, maybe a little bit, the Maldives, not in Bhutan, So therefore, I think Gayatri's point about making sure that that free speech resistance is linked to the underlying right is therefore then very important. I think one place that as a community of people that work in this area, we are lagging behind a bit is on how to frame legally ancillary attacks on media houses as attacks against the freedom of expression, right? Tax raids is a classic example. And while timing can play a role in the positioning of this in the media that reports these cases, in court, I think they say that, look, if you violated this tax statute or some, whatever it is, right? The SEBI, the securities fraud statute, or whatever it is, right? The fact that you were also reporting is not relevant. Everyone is equal before the law. That's the kind of approach that's taken. And I think in our legal thinking, I think we haven't quite cracked that. Like, how do we bring this freedom of expression thing front and center? Only in cases where it's very obviously egregious does it become a thing that one can even say, and I think that Ragini's point that everyone is bound by the Constitution, and to remind these judges that are making decisions under taxing statutes that you are meant to keep that in mind as a lens, keep the Constitution in mind, is significant. How you place evidence that they're being attacked because they're journalists can only at best be circumstantial. But I really think that we need to build on that. Even if it's circumstantial, build on that, put it before the court, build the jurisprudence on that. And I think in that regard, Ramiro, the more evidence, that's a role that we can play in a very positive way on the database. Because if there is emerging jurisprudence on this, anything we can use will be significant. Sadaf, the JDC, I think, is just fantastic, and I just wanted to say that the overbreath and the chilling effect point that you were making, the fact that proportionality was being discussed for the first time, and necessity of these ideas were being discussed for the first time. I don't know. It's probably a political hot potato to cite Indian judgments, but in Shreya Singhal, for the first time, and we were very clear to frame it in these terms, right? We framed the challenge as a chilling effect and an overbreath challenge, amongst other things. And for the first time in India's Supreme Court jurisdiction, a law was struck down for that reason. So therefore, it was in the ratio, Now, while I think it would be difficult, although I did cite the Pakistan jurisprudence in, and there's a way I think it can be cited, so for example, in the marital rape case, which involves issues of free expression of sexuality, one of the things we said was that in Pakistan, marital rape is a crime, So therefore that's like, competitive thing. But for in Shreya Singhal, the judge was very clear that the US jurisprudence isn't actually that far from ours, And I think looking at the underlying thinking and the judgments that are cited then can get useful, even if you can't cite judgments from a particular regime. But I'm going to end there. Thank you, everyone, so much. And thank you, Ramiro, for involving us in this.
Thank you very much, Karuna, and thank you, everybody. On behalf of the Global Freedom of Expression Project at Columbia, but also personally, it was an absolute privilege to learn from you. So thank you very much for sharing this space with us. And we'll be in touch. For those viewing on YouTube, there's going to be a workshop on March the 10th. check our social media for the specific time, and it will cover the regions of Middle East, North Africa, and Africa.